Hello everybody and welcome to this episode of Activist Lawyer. I'm here in the studio with Jack.
Hello everyone.
And today we have a special guest who's joined us all the way from Strasbourg, but is pretty local to us here. It's Michael Clements. Michael, thank you so much for coming into the studio.
Well, thank you for having me.
Yeah, and into the studio. Thanks for making the effort to come in as well. It's great to have somebody in person too. So just a brief introduction to your background, then we'll get into your work in a little bit more detail. Michael is a human rights lawyer in the Registry of the European Court of Human Rights. He's responsible for filtering and assessing new applications to the court and dealing with interim measures applications for both the UK and Ireland. Michael completed an undergraduate degree in law and criminology and has a Master's of Law in Human Rights Law and Transitional Justice. Michael, during his training in KRW law, assisted on the running of High Court actions relating to legacy matters, personal injury, Article 2 inquests and non-Article 2 inquests. Responsible for numerous High Court actions, Circuit Court actions, inquests and criminal matters in the Republic of Ireland also. He was admitted to the role of solicitors in Northern Ireland in October 2021 and admitted to the role of solicitors in the Republic of Ireland in February of this year. Michael is also a member of the Haldane Society of Socialist Lawyers and the European Association of Lawyers for Democracy and Human Rights. Welcome again, Michael.
Thank you very much.
Right, a lot to get through there, and it's really interesting. We haven't had anybody on from with that expertise in terms of the European Court of Human Rights. So it's interesting to get into your work there. But just before we go into that a little bit further, can you give our listeners maybe just a little bit of background about yourself and your journey into your legal career, which is quite niche?
Yeah, well, I think, in terms of going into law, it's not something I'd always thought about or really known I had an interest in, I guess. Mm-hmm. I did my degree in, it was law with criminology, and actually, to be honest, it was maybe the criminology side that interested me more, but when I actually got into the law side of things, I picked that up a bit more, and I suppose law is always seen as a good degree to have, so I think that's honestly the most amount of thought I'd given it at the time. But and I remember in my third year I had a module on transitional justice, and I found that really, really interesting actually. It sort of stuck with me. Mm-hmm. And then when I finished my law degree again, I had no idea what I was going to do, and I cleared off to Australia for a year just to try and figure things out. Yep. Exactly. And it was then that I was thinking about, I'm coming home soon, what am I going to do next? And I had noticed the Human Rights Masters. But again, it was that transitional justice module that had sort of stuck with me, and that was the reason I decided, okay, we'll go for this. And actually, when doing the Masters, it was the human rights part of it that stuck out more to me, really. Yeah. I really, really enjoyed that. That's how I learnt about the court where I am now, and just it sort of opened that window into that world a bit more. And then I worked at a couple of corporate firms in Belfast, but at the same time, always trying to kind of get into human rights or something that I found interesting. So while I was working there, I was doing a lot of different internships and traineeships and volunteering and things like that. And one of them was actually at KRW Law. So I think it was a day a week for a few months. And that was a really, really good way to get into a firm that was working on human rights. Sure, yeah. And just to get a bit of experience in the office, really, and make some connections and things like that. And I do remember after maybe about a year after I'd graduated, just really thinking, like, why am I not working in human rights yet? Why is this not working? What's happening? And it was actually around that time then I got a phone call from the European Court of Human Rights and was offered a traineeship there. Brilliant. So that was end of 2017. I started the traineeship then at the start of 2018, and that was fantastic. It was 5 months at the court working directly under one of the judges. So I was assigned to the Ukrainian judge. And it was just basically what the judges needed assistance with. So it was a lot of research and drafting and attending hearings and things like that, which was a fantastic experience. I really, really enjoyed it. So, yeah. And that's, again, how I got to learn a bit more about the court and how it works. And even I found out about my current job then as well, or that the position existed, really. So I returned then back home, and through having done volunteering and my time at the court then, I was able to get a job at KRW as a paralegal. And I did that for about a year until I started my training contract then in September 2019. of course, I started my training contract, and this job at the court was advertised, and I thought, I can't apply for it. I have 2 years to do. But I thought, I'll go ahead. They have a reserve list. I'll try and get onto the reserve list and see what happens. So I chipped away then at the institute and through my training contract, and then in July 2020, I was offered my current role. And I had another panic attack. I had about another year of my training contract left to do. So I had been in touch with the Law Society about the possibility that this might happen, and mainly with Anne Devlin. I think she's just left, actually, but she was fantastic. I had to beg the court to push my start date back.
Okay.
So it had to be after I completed my exams at the institute, and then I had to beg the Law Society to allow me to finish my in-office training at the court. And I had to make like submissions to the education committee and things like that. So it was about a month, I think, by the time I'd got my final answer from everybody. But it was the most stressful summer.
The stress.
Yeah, it wasn't fun. But no, everybody was fantastic. Everybody was really helpful.
Yeah,
and they signed off that I could finish my training.
Oh, thank goodness.
So I was offered the job, and I started in January 2021 then, just after I'd finished my exams at the institute. And not a lovely time to move to France, just with lockdowns, just thinking, and everything.
Wow, God, that was a lot, yeah.
And then so I've been working in the role now for just under a year and a half, and then because I was allowed to use my time in Strasbourg to finish my training contract, then I actually qualified as a solicitor then October passed.
Okay.
And then I thought I'd known you could apply to go on the role in the south as well, so I just sort of thought I may as well.
Absolutely.
Especially in terms of when I'm coming home from France, it's just best to have as many qualifications as I can. So, that's kind of my background and how I got where I am.
That's so interesting. I've heard that before with people. You're often in that position where trainee contracts are often, and the right one, the one for you, they're difficult to come by. But then if you're offered such an amazing opportunity that came your way, fair play to you for, trying to push that through, because I'm sure, people in that position might, not have done that and would have remained in the contract and then potentially have lost the opportunity. So that's good. And it's good to hear that there were inroads there that you could make in terms of pursuing both.
No, absolutely.
So congratulations on that.
Thank you very much.
Yeah, and how was it completing basically half of your training contract here in Northern Ireland, and then completing the rest? It was
strange. I mean, obviously, in terms of the actual training contract and qualifying as the solicitor, it doesn't play into my current role because you don't actually need to be you're not practicing technically, so you don't actually need to be qualified. Obviously, it helps. So there's an element of distance where you're not thinking about it as much. It was very much. I mean, I might not have even applied for the job because of the training contract, and as I say, my mind was to get onto the reserve list. So I was offered this amazing opportunity, and
couldn't turn it down.
Yeah, exactly. But obviously within law, it's very much training contracts are gold dust, and you don't turn them down either. So I was just really, really lucky that it worked out well for me, and also that I was able to start in my current job, but work towards qualifying at the same time. So I got the best of both worlds in that sense.
Fantastic. So you're at the Registry of the European Court of Human Rights. Could you just maybe explain to listeners a little bit about the institution, the organisation, and what not exactly that you do, because I'm sure it's very wide ranging. And we'll look at a little bit more into your work shortly, but just in terms of, the setup.
Yeah, of course. So the overall body is called the Council of Europe. It was started after the Second World War. And it is completely separate from the EU, although they do have a lot of, it does get very confusing. I mean, we have an EU Parliament is right beside us in Strasbourg as well.
But nothing to do with...
No, but very closely linked in terms of different projects and things, but completely separate bodies. The Council of Europe has 46 member states. So it has a lot of countries that aren't EU members, but as I said, there's a lot of kind of working between the two. But so it's the Council of Europe, and then within that, there's the European Court of Human Rights was set up. I think it was the 1950s maybe, but it became a full-time court in 1998. Before then, it didn't sit all the time, and now it does. So as I say, it's 46 member states. It was 47, although Russia have been removed as a member of the Council of Europe. So they have, I think there's something like 13,000 pending cases. So I'm not involved in any of that, obviously. So I'm not sure what's happening there. But basically, what happens is within the court you have the registry, which is all the lawyers in the court, and our jobs are to deal with applications that come in. That can be, my job is mainly filtering applications. So, do they meet the admissibility criteria? Are the applications filled in properly? And are the legal arguments relevant? Are they arguing under the convention properly? And then the steps up from that are the more serious cases where lawyers, some of the senior lawyers then will draft judgments and things like that and work quite closely with the judges within the court. But as I say, it's separated out into each individual member state will have its own team basically within the court. So I work on the Irish and UK cases and only those. Okay. So I don't touch cases from any other country unless, there's maybe crossover. Some people, you can make applications against multiple member states, for example. So there can be some crossover. But my day-to-day is really, there's myself and another assistant lawyer, and the two of us deal with every application that comes in against the UK and Ireland at the moment. We
just two of you there to filter those?
Just two of us. We've quite a small team. Yeah. The UK and Ireland unit is two assistant lawyers, myself and another, and then two senior lawyers. So it is quite a small team. I think higher case count countries like Turkey or Ukraine or Romania, for example, they maybe have 30 or 40 people in their team. So it really dictates the amount of cases you get in, dictates how many people actually work in the team. So we're a relatively low case count country. But the UK is interesting because we don't get that many cases, but we do get some big ones. So I suppose I'll talk about those a bit later, but they'll
might have a few more coming your way the next couple of years, I expect.
And then another element of our work is dealing with interim measures applications. So that can be if something is imminent, something serious is about to happen. You can make an application to the court basically asking them to stop something or to take a positive action. Normally it's in terms of deportation or extradition cases. So it tends to be, or the most common will be someone is being sent to a certain country and they think, or they're submitting that being sent there will be a violation of one of their human rights. So the court will then, obviously if there's merit to it, the court can step in with an interim measure and that stays everything until the full case is heard. So we have to deal with those, which can be quite stressful, and they can come in at any time as well. So we get a few of them. It's been a bit quieter recently, but last year was quite busy.
And is that Ireland and UK together then?
Yeah, although there's almost never against Ireland. I don't think I've seen any. I think I may have actually submitted the very last Irish one in 2019 when I worked at KRW.
No way.
Yeah, I think so. I'm not 100% sure, but I need to check that. But so there's very few coming in against Ireland in the same way. But
and those cases, obviously, the extradition cases take in, the criminal law aspect as well. Is that something, I know, your background was very much involved in, and your degree as well in terms of criminology. Does that really interest you to get those cases before you?
Yeah.
Or, are there any other areas within your work that you'd be...
Well, it's such a wide net in terms of, human rights is everything, and we get everything. We get employment, we get family law, we get criminal, we get a lot of criminal actually, a lot of immigration stuff as well. I think, to be honest, I just quite enjoy the variety of it all.
Yeah, that's good.
And just every file you're going to pick up is something different and something new. So, yeah, it's also good in terms of, this is so I maybe didn't explain the actual role I'm in properly in that sense, that it's a fixed term contract. So it's called an assistant lawyer scheme. The idea is that you bring people from all over Europe to work in the court for a fixed term. Okay. And then the idea is they've learned how the court works and they can go back to their home jurisdiction then.
And understand and practice how. That's really interesting.
So my mindset from basically arriving is, what am I doing after this? There has to be an end to it. So in terms of working on files and cases that deal with every type of law, it's really helpful to have a wide variety of experience from that and kind of learn, because we have to sit and read through, have they used the right appeal here? Have they gone to the right, through the right processes? Have they, raised the right points and things like that?
Because of course all domestic remedies have to be exhausted first.
Exactly.
So you get
I don't know if you want me to do a full breakdown of the court's admissibility criteria. It can take a wee while. Well, that's one of the main ones in terms of you need to exhaust. You can't just come to the court and say, my Article 3 rights have been violated. You need to give the domestic courts a chance to review that first. The court sees itself, I think, in some ways as a body with oversight over, or maybe more so in looking over the domestic courts and making sure that they are implementing the convention properly. But the court's always kind of hesitant to step in first. It wants the domestic courts to have its first look, basically. So that is the biggest one in terms of you need to take your case to the domestic courts first. But in terms of us going through applications, it has to be to the right domestic court. You can't just take it to anyone, and that's part of our job, is assessing, okay, have they gone to the right court? Have they appealed to the right court? And that can get quite complex at times, and you're having to do a bit of research on what the appeal process is. So,
sure. And at that point, you could say, well, we're not going to be able to admit it because
exactly.
Exactly.
So that's probably where most cases fall down, is technicalities and not
big time. Yeah. So we actually have a stage before that. It's called Rule 47, which is how you fill in the application form, and that can be very strict. In terms of if it's not signed, if certain sections aren't filled in, we just don't look at it. It's gone. Now, measures like that, I think, come from us having such high case count countries, because these measures apply across the court. So you have, Turkey, Russia previously, Romania and Ukraine. The countries like that, with getting so many, they get thousands. They need to find ways to kind of filter through them, and these measures have come in, which, when applied to our lower case count, maybe seem a lot more stringent or strict. But it is kind of a court-wide practice. So that's the first stage. Is just, has the application form been filled in properly? Have we been given all the documents we need as well? That's quite an important one, actually. We'll get applications where, the applicant will say, I went to the Court of Appeal, but there's no Court of Appeal judgment there, and you can't make a decision without knowing what the Court of Appeal have said. So that's the first stage. And then after that, you move on to admissibility criteria, which is exhaustion of domestic remedies, but it's also, it has to be within 6 months of the final decision.
Okay, so some pressure there to get,
which has actually now just changed to 4 months. They've brought a new protocol in from the start of February. So any final decisions after the start of February, you need to bring your application within 4 months of that. So again, I think these are measures coming from the higher case count countries where they're applying them across the board.
Okay.
So, but yeah, I mean, that's our job, is to assess all this, and it can be quite tricky. We haven't, I wouldn't say there's a massive difference even between, we get a lot of lay litigants applying.
I was going to ask that, what type of people come before you, or
it's
who's bringing mix. The case?
Yeah, I mean, I would say most of them are from lay litigants and people who have been taking their own cases through domestic courts. We get quite a lot of that.
Right, interesting.
But we do get a lot from law firms as well. But honestly, sometimes it's not a clear distinction when a law firm is submitting them that they've done everything right. It's not always a foregone conclusion that it's exactly, which is it's interesting. But again, it's quite a complex procedure, and in terms of the actual idea of the job I'm doing is for me to learn that procedure so that I can bring that skill home with me, I guess. So it takes a while to get used to, but that's kind of the basics of it, I guess.
That's so interesting. To understand how in practice that works. And I suppose it makes sense to have it as a fixed term position, so that I get that, well, such skills that you bring back to wherever you end up working after this. Just in terms, you mentioned there Article 3, and we talked a little bit about extradition. They're probably cases, I think you mentioned that they come up quite frequently, more than others, from probably both the UK and Ireland. I was looking at one that you'd mentioned, I think there was a recent press release, it was 2022, was it? Sanchez. Just by way of example, I think it's a really interesting case just to see in practice how this works. If you want to just maybe bring listeners through it. Jack and I had a good read at it before, but we're like, God, how does this work in practice? But yeah,
of course. So I haven't directly worked on Sanchez. You will notice the cases application numbers or the dates on them will be a few years before they actually come before the court. I suppose that's the same with any court, to be fair. But so while I haven't directly worked on it, I have worked on cases that have come in after it, that are following it and have all been set aside. Now they'll follow whatever decision comes out of this case. So so it went before the Grand Chamber. It was heard beside another case against Italy. But basically the question being asked is in relation to extradition to the United States. And in terms of the US has life sentences without parole, basically. And the court has found there was a case called Vinter, basically that is not compatible with Article 3, that you can't give someone a life sentence with just absolutely no possibility of parole. Now, the question here is, how do you implement that in terms of extradition? Because one of the ideas behind extradition cases at the court is, if a member state is going to send someone to a third party country that's not a member state, and there's a risk or a possibility that they could have one of their human rights violated, then it's the member state's responsibility to make sure not to send them, or to make sure that if they are sent, that their rights are protected. So a lot of the times what you will see are assurances from third parties saying, they'll be held in these conditions and they'll be given, this will be how their trial works out. So it's quite an important area, and especially with the UK, we deal with a lot of deportation cases. This one obviously then asks, how do you implement something that happens within the convention system to the US in terms of their system? And it can get a bit messy then, whenever it's a completely different legal jurisdiction. So there'll be interesting judgments when they come out.
Absolutely. But and I was looking at it there. So do you, sorry, forgive my ignorance, but the case is obviously taken against the United Kingdom, and their decisions are under scrutiny.
Yes.
You said is it likely that the US would intervene in cases like this, just to give that level of assurance? I know it doesn't mention it here, but it strikes me as the reason that this person had brought the case was relying on Article 3, which is the prohibition of inhumane or degrading treatment. It was based on him potentially suffering imminent and irreparable harm in the form of this life sentence without parole, which is obviously the jurisdiction apply, or the rules applied in the US. That strikes me as being one that would arise potentially quite a lot if that's their standard system. Or
it would be most of our, in terms of the US, I think there's this one, and then I think I've dealt with maybe 2 or 3 that have followed this, so there's maybe about 4 or 5 against the UK in general. And then, as I said, that one went to the Grand Chamber. I can go through the different chambers of the court if you want at some point, but that one went to the Grand Chamber alongside a case against Italy, so it's not, and I think there's a couple of other countries that have had similar things, so it is kind of
it's interesting just to see how different jurisdictions will play into it. I'm just wondering how, this might be a question that you can answer, well, it won't be because nobody can see into the future, but I imagine not deportations, which it's almost worse, offshore processing of asylum claims to Rwanda,
one-way tickets,
has to be, in anybody's eyes, a clear breach of many legal instruments, including human rights, the European Human Rights Convention. Do you have any thoughts on that, or has it been discussed among your colleagues? Because it came around so fast that we're still trying to get our heads around it. We obviously don't know what's going to happen, but the deal seems to be signed, sealed and delivered. And as immigration lawyers that we are in our daily jobs, I mean, we're just kind of sitting still scratching our heads thinking, how on earth can this happen? And I think the government are expecting, they clearly said they're expecting legal challenges. So, I mean, I'd say that might be, you might get busier.
Yeah, I mean, obviously it was announced so quickly that I don't know if we've had time to even think about it too much, but I mean, we are certainly expecting something eventually.
Yeah, sure.
Obviously it needs to go through the domestic courts first. It could be that we get some of these interim measures applications. That's the way we would get it the quickest. It just depends how they are framed. And what the conditions in Rwanda are going. I mean, obviously one of the main things is that Rwanda is outside of the Council of Europe. And it's not party to the convention. So that could cause issues as well, that people are being sent to somewhere that isn't a member state or hasn't signed up to the convention. So that it's definitely something. I mean, I suppose the way we work, because it takes so long for things to get through the domestic courts, everything's offset by a few years almost. So
it'll be interesting to see if there are any interim measures brought. But just on that point, talking about the UK and the government, how did Brexit, or does Brexit impact your work in terms of maybe numbers coming through? Is there confusion there between, the fact that you're separate from the EU institutions? Have you noticed anything that might?
Big time, I started January 21, so just after withdrawal had officially happened, and I remember getting applications then, people saying, you need to stop the UK from leaving. They're like, we can't, it's not us. I mean, there's a lot of confusion between the two bodies, and anytime I'm talking to people, I have to clarify it's not an EU body. So in terms of my actual work or the work of the Council of Europe, it hasn't changed anything.
Okay.
I think my Scottish colleague had to get like residence permit or something.
You're kidding.
So I think that in terms of practicalities, that's all that changed.
Yes.
But we have noticed that cases coming in have gone down, and we think that's part of it, where people obviously confuse the two and think they can't apply to us basically anymore. So yeah, I think that's definitely played a part in it.
My goodness.
Yeah, you would get confused though, and you're thinking European, you would.
Yeah.
And I think even from the press and media, I mean, that's confusing for people unless you're working, like even from our end, I mean, we're lawyers as such, but you don't really think of it. But I mean, that's why we have guests like you on the show to explain your work. But
yeah, so Sarah mentioned previously that you're a member of the European Association of Lawyers for Democracy and Human Rights, and also a member of the Haldane Society of Socialist Lawyers. So we had a previous guest, Declan Owens, who was on. If you just want to give an insight as well, if you just want to give the listeners an insight into your experience of both of those groups or societies.
Yeah, I don't know how much I can really give. I mean, I have only recently actually qualified as solicitor, so following that I joined both of the groups. I think it helps, obviously, having solicitors and lawyers across Europe are all in one, and not one place obviously with everything going on, but contributing together and working together and things like that. But I am quite new to both of them, so but for me it's I suppose law in general is very much about having connections and branching out and things like that. So
I think it's the same as here, though. We find that bringing lawyers on, even just on this podcast, and with you with immigration solicitors, it's good to have a group of people.
Absolutely. I'd be lost.
Yeah, because sometimes you can just be by yourself as a solicitor and feel like you've no one to go to and no one to ask. Especially
in practice as well, you can feel quite isolated if you were by yourself. So I feel showing up at events even, or taking part in groups like that where you're speaking with peers, you get to know them and you're learning all the time as well. I mean, I don't think any of us are experts. I'm certainly not an expert, especially this week. I haven't a clue what's going on in immigration. But I mean, I think it's important. And as you said, you starting out in your legal journey, it's been, well, really interesting start to it. Just in terms of cases that are, I suppose, you're working with UK and Irish matters that are brought before you. Has anything interesting arisen in terms of Northern Ireland or any legacy cases? Because we would have had quite a few lawyers on who worked on legacy cases and cases, ongoing from the Troubles. And I know the Article 2 in particular would have played a huge part in that as well. Have you any experience?
I mean, my background before the court was in a lot of legacy work at KRW as well. So I had that experience, more direct experience. The court in general has its Article 2 case law has really developed from the conflict here. Ireland and the North and South has had a bit of historical relationship. I mean, the first ever case the court dealt with in, was it 1950 or something, was against Ireland. It was an Irish case about internment. And then obviously one of the biggest interstate cases was Ireland against UK, which related to the Hooded Men in the 1970s. So Ireland's always had a bit of a special relationship in terms of the court. With Article 2, that's one that's more developed in the last 30 years possibly. But that has been a big area that has developed. You look at the court actually has really handy case law guides if anyone's interested in looking into the articles themselves. If you look through the Article 2 one, it's a lot of cases against the UK relating to Northern Ireland and Turkey, I think, as well, with the conflict they had. So Northern Ireland has been, I suppose, in some ways very key to the development of the case law in that area. There are a number of cases at the minute. I think they're called the McCurr group of cases. There's about, I think, 8 of them. I don't know if I'll explain this properly, but there's a committee of ministers within the Council of Europe, and they are the body with oversight over the whole organisation. And basically part of their job is, once the court makes a judgment, the Committee of Ministers are involved in execution of judgments. There's a department that deal with that, basically making sure the member states have done what they've been asked to, or have actually executed the judgment as it was written. Now, these McCurr cases have been ongoing for some time, and I think the Committee of Ministers brought out a statement recently basically saying it's not good enough, legacy investigations need to happen in these cases, and it's not good enough that they haven't, basically. So it's kind of one of those difficult ones that's ongoing, and we've seen talk of amnesties and different proposals to deal with the legacy. So those obviously haven't been before the court or anything like that, but it's definitely an area the court has been very involved in, and even a lot of the domestic cases I worked on and the legacy cases here, a lot of them quote the court's case law as very important in terms of how those are litigated.
That's so interesting. So they were really integral in the development then of
Absolutely.
that area. That's so interesting. And as you said, there's resources there that anybody can check.
Yeah, they're really easy to find. There's case law guides for the court. So I think all the major articles of the convention have their own one. It just sets out basic principles and gives examples of cases throughout.
Sure.
So
That's
they're
some
quite a
key
good
reading
resource
for people. There you go. Yeah, and many of our listeners are young aspiring lawyers and students and people who've just qualified. So if you could give some of them advice, just obviously you've had a unique journey to becoming a lawyer. If you could just give some of that advice to anyone who's beginning their journey into law.
Yeah, I mean, I think one of the things I've always done is just go for any opportunity that comes up. Even when I was working in some of the corporate firms, I was always trying to find an internship or a volunteering position or just anything that I find interesting but might help. Even, I mean, applying for the job I'm in now, I was close to not doing it, but I'm glad I did, obviously. So it is really just about taking any and all opportunities you can and that come up. Obviously, the big thing is finding where your interest lies and how you get there. But I think actually I sort of stumbled across my interest by doing a lot of those different internships and volunteering and just taking any opportunity. Sometimes you won't enjoy it and sometimes you will. But
at least you're learning from each experience, and one door leads to another opening.
Exactly.
But in terms of a lot of our guests as well have worked abroad, especially when it comes to human rights lawyers, they do take that opportunity. Do you think that's important for you? And, would you recommend, taking even a year or two out to work abroad? What's the experience like in terms of...
Yeah, I mean, I think everyone should spend some time abroad, to be honest. I think it's a good experience. I mean, obviously I travelled Australia for a bit, but that wasn't really work related at all. But even that was a good experience in terms of kind of getting out and seeing the world a bit more. But in terms of career, it's really good. Obviously I did my internship at the court in 2018 and that was good just in terms of, well, obviously the work was really interesting, but I got to know people who are now lawyers all over Europe, basically. You have that network. I mean, it doesn't always play into your day-to-day, but it's always good to know people dealing with different things across Europe. And obviously now I'm based in Strasbourg again, and you build that network a bit more. So, I think it's important to figure out what other countries are dealing with, what other lawyers are dealing with, and it's been a fantastic experience.
Nice place to live.
It's lovely, although now that COVID's gone, it's lovely.
Is it? Yeah, has it opened up properly? Yeah.
It's back to normal now, but it's lovely.
That's fantastic. Well, just finally, Michael, the question that we ask all of our guests on the Activist Lawyer podcast: and your role is very unique. What does activism mean to you in terms of the law, and how can we use it to affect change?
I think one of the biggest things for me, maybe more so from my training contract, and to be fair, I kind of see it from the other side now, and one of the most important things for lawyers in general, I find, is providing accessibility to clients and to people who, I think when you work in law, it can become normalised or you get used to it, whereas people outside just haven't. It's so confusing, and it's understandably confusing, so I deal with that a lot with applications coming in, people making arguments that you're like, that's fair, but that's not how that works, or that's not how that convention is applied. So I think that's a big thing in terms of the lawyer's role in activism is assisting in that sense, or opening that door in many ways. I think at the same time, I think some of the biggest changes have almost come from changing the law as opposed to within it. I think Repeal the Eighth was a big one,
Massive,
and you see that kind of mass movement, but it's always linked with the law in some ways, and there are legal challenges that need to happen alongside that as well. So I suppose it's being involved in both sides. I mean, in the activism and the lawyer, and both together, obviously, as well. But yeah, I think it's just important to be, especially as a lawyer, to be there for people who just, they're probably in their, you know, you're not going to meet many people in the best part of their lives when they're having to go to a lawyer. So it's really about,
and especially in the area that you work in too, you know.
No, absolutely. So I do think it's about accessibility, and that's what we're there for, I guess, at the end of the day.
Access to justice. Well, look, I am just delighted to hear more about your particular experience, and I'm really keen to find out what you do next as well.
Me too.
Yeah, well, tell us whenever you find out yourself. But it's been really great to have you on. I really appreciate you coming to meet us today at the studio, and I'm sure people listening will have lots of food for thought in terms of your legal journey, which is only starting, only beginning. Well, look, thank you so much, Michael, for joining us today.
Thanks for having me.
No problem. Talk soon.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.